Hello, everyone. Good afternoon. My name is Jocelyn Larkin, and this is a panel on the implications of COVID-19 for federal and state civil rules. As I mentioned, my name is Jocelyn Larkin. I am the Executive Director of the Impact Fund here in Berkeley. We are a legal nonprofit, and we focus on supporting lawyers who are doing impact litigation. And I'm also a member of the CJRI Advisory Board. We have an excellent panel today, and I'd like to introduce them before we get started. So first we have Rick Marcus. He is a distinguished professor at UC Hastings School of Law. His scholarship focuses on litigation and civil procedure. Importantly, for our purposes today, he's the associate reporter to the Advisory Committee on Civil Rules of the Judicial Conference of the U.S., and has played a principal role in drafting amendments to the federal rules of civil procedure over the last 20 years, including class actions, discovery, some very important things. Next, we have Tara Sutton. Tara is a partner at Robbins Kaplan and the chair of their National Mass Torts Group. Her trial practice focuses on representing individuals harmed by the pharmaceutical and medical device industry. So welcome, Tara. Bob Giffra is a partner at Sullivan & Cromwell. Mr. Giffra is currently the National Coordinating Counsel for Volkswagen in its recent diesel-related matters and is lead counsel to Fiat Chrysler in its emissions issues. He's currently serving on the Standing Committee on the Rules of Practice and Procedure, and also has been involved with an effort in New York to take a look at the state rules and practice in light of the current emergency that we're in. Finally, we have Andrew Bratt, and Andrew is a professor of law at Berkeley. He too focuses on civil procedure, conflicts, and remedies, and he has a particular focus on multi-district litigation. So to get us started, let me just give us just a little bit of background here on the rules. The Coronavirus Aid, Relief, and Economic Security Act, which we all know as the CARES Act, was signed into law on March 27th, 2020. And most of us think of it as a multi-trillion-dollar bill trying to keep our country, our economy, and individuals and businesses afloat. But Section 15,002B6 requires that the Judicial Council and the Supreme Court consider rule amendments that address emergency measures that may be taken by the federal courts when the president declares a national emergency. So, Professor Marcus you've been intimately involved in this work. Why don't you start us off by explaining what's been happening?
Okay, well, I'm going to do that with a little bit of a blast from the past. I partly am doing that because for those of you who attended this morning's session, the occasion came up in connection with some technology-related discovery amendments that happened now started 20 years ago. The basic issue for the rulemakers, in view of what Congress said, has been for the last 6 months thinking about something that I'll say a bit about, but I think probably is not of prime interest to those participating here today, and that is a possible rule that authorizes flexibility or deviations from the ordinary rules during times of emergency. Now, Bob Giffra and Judge Carolyn Kuhl, who was on the first panel, are both members of the Standing Committee. They'll hear plenty about this at the Standing Committee meeting in January. I'll say a bit about it here, and anybody who's interested could look at the agenda book for the Advisory Committee meeting that is 2 weeks from tomorrow, which you can find on the Administrative Office website. But I think if you are interested in seeing what that looks like, the thing to do is wait until August and see if a preliminary draft is published for public comment. Then I'll say a few words about the issues presented there, but my main focus is going to be on what happens afterward, whether or not there's an emergency, what is the new normal? That was one of the big topics this morning. Whether the new normal is new or will be normal is unknown at present. What Congress did in the CARES Act, besides this directive that the rulemakers consider an emergency rule, is it had a whole bunch of things about criminal cases that authorized non-in-person events for detention hearings, an initial appearance, preliminary hearings, plea changes, and a lot of other things. And one of the points I'll return to in a moment is, actually, it seems that for those, if there are any who handle criminal cases as well, the criminal rules are a lot less flexible than the civil rules. So those who have been in civil cases in federal court have probably seen things operating very differently since mid-March, but none of that required Congress to do anything, and it isn't apparent that any of it required the rulemakers to do anything. So what we have then is, and I'll just run through the issues so that I can switch to where I think our focus should be. What we have is an intercommittee negotiation among bankruptcy rules, criminal rules, and civil rules concerning what such emergency rules in these various sets should look like. Probably nobody's in favor of saying what Congress said, a presidential declaration of national emergency, because that doesn't seem to deal with local emergencies. That doesn't seem to be a suitable trigger. There's one of them that's been in effect since 1979, which is sanctions against Iran. Who should be able to call? What are the criteria if it's not a presidential declaration? Who should be able to declare such an emergency? Should it be any rule can be avoided, overlooked, even the right to jury trial? Should it last for an open-ended period, or 90 days is an idea? Should it be renewable, and if so, how? And what do you do if it ends and you're in the middle of doing something that was undertaken under an emergency provision that no longer applies as of the time you're getting finished or you go to trial or whatever we're talking about? Those are all interesting issues, and between now and next August, probably they will get worked out. But I think that the experience, it seems to me from hearing about what's happened around the country, not only in federal courts, but in state courts, that the courts have largely been quite creative, been quite flexible, and what's really happened is that people have learned a lot they didn't know before. And they've learned about different ways of doing things, which may mean that after this is behind us, we're going to need to go look at some of the rules that we do have and ask whether they should be changed just as a general matter. So I want to say a few things about that, and then I will stop talking. That's kind of a blast from the past. One of the speakers this morning said regarding depositions, I'll return to that. One of the speakers said, if we can only have rules, they're going to have to work up what exactly should be the way of handling remote depositions. And that's the same kind of thing said this lawyer from O'Melveny this morning, Charles Lipton, I think is his name, that happened with e-discovery. Well, I was there at the beginning in e-discovery. I'm the guy who wrote those rules. And I'm here to tell you that in January 1997, a lot of lawyers told us, you got to do something about e-discovery. Well, actually, it was just discovery email then. Nobody had thought of social media or Facebook or a lot of other things. And so the question we had for them was, okay, what? Well, we don't know, just do something, was the response. Took almost 10 years to figure out what to do. So I think there's a learning curve ahead. And where will that learning curve focus? To my mind, number one, and this was mentioned several times this morning, is remote depositions. What's the appropriate way to handle those? Should there be a rule that says what that is? Mr. Liffland, I think, said, well, it takes so long to negotiate the protocol. Maybe with experience, we can determine what that should be and put it in a rule. We certainly do not have that experience now. Second, remote trials. Rule 43A says that maybe sometimes a witness can testify in open court by remote means, but only really, really rarely. Maybe that should be changed. That's a major question open for consideration, at least in court trials. In some places in this country already, there have been court trials by Zoom. And people have seemed fairly satisfied with that. Third, many or all of you have probably attended hearings via Zoom. Where was the judge? There is a rule, Rule 77B, that says no hearing may be conducted outside the district in which the judge is assigned. So one hypothetical is, how about a District of Columbia judge who handles a hearing via Zoom from her study in her home in Maryland? I bet you things like that have happened. Do we need to change the rules? Not clear. After Katrina, Congress did act 28 U.S.C. Section 141 that says you can have proceedings outside the district under certain circumstances. I don't think anybody's done anything formal about that, and maybe nothing need to be done. The reality presently is something that my students, whom, like Andrew, I'm teaching via Zoom, satisfy their go-to-court requirement that I have for them by going by Zoom. So they are beginning to learn what the practicing bar has been dealing with. And maybe the rest of us can learn from that once, heaven help us if this is a long time from now, once the pandemic pressure is off, what should we be doing differently on a long-term basis? So I'm all ears to hear what the others have to say. Thanks for listening.
So Rick, I just have a couple of questions. The civil rules, I think, are correctly lauded for their flexibility, and I know you've played a big role in ensuring that they are very flexible. So given that, where do you come down on having a general emergency rule versus potentially just sort of specific changes to specific rules, or between any change and no change?
Well, I guess the first thing I'd say, because I see Bob Jeffrey here listening in, is I just work there. And these decisions are made by people who are at a higher level than me. I suppose what one can take from experience so far is that there's no, compared to the criminal rules where Congress had to act, there's no huge need for a civil rule change. So the other thing I was saying is whether or not there's a need to change as an ongoing matter in the rules I mentioned, in view of an actual change in behavior, is separate to me. The other question you asked is what we sometimes describe as a negative versus a positive emergency rule. Is a negative emergency rule says you can change anything you want except the following: Rule 38 on jury trial, Rule 23 on class action, and some others, maybe the service rule. You can't just skip service of process under Rule 4. A positive rule says, well, if the judicial conference or somebody says it's necessary, you can change the following rules. And if you look at our draft, that actually says in the following ways. So frankly, the pressure point for emergency is not civil cases, it's criminal cases.
So obviously the other element of the civil rules process is that it is deliberative, and it is careful, and it is slow. And I think many of us feel very strongly that that's a very good thing. But what does that mean in the context of having to respond as we are? So if we can think about protocols for remote depositions and other things, what would the timing be? I think it would be helpful for people to understand what a rule process timing would be, and what mechanisms might there be to do things maybe by standing order or something more quickly, given that we are, on the ground trying to deal with these issues.
First, I forgot to mention in terms of lickety-split action that if there is an emergency rule, it will speed into effect no sooner than December 1, 2023. We all hope that this lockdown situation will be behind us then. The California legislature, I believe, actually has adopted changes to the California Civil Procedure Code to address some things about remote depositions. That might be a learning opportunity for the federal rulemakers going forward after things settle down. The need for such an arrangement is unclear on that particular point. Rule 30b-4 says the court can order already now, even over a party's objection, can order such depositions. We've received a number of suggestions that the requirement for an order should be removed. And if you remember the videotape deposition dispute of 25 years ago, and a party can simply pick which way it wants to take the deposition. But that might leave open some questions about, should we provide some guardrails for doing that? I frankly don't know what those guardrails should be, but it would be important to get a pretty clear fix on that. So all of this is very deliberative, takes time, and that's why the e-discovery rules took almost a decade.
I remember. Bob, can I ask you now to talk to us a little bit about what's happening on the ground in your practice, and also what's going on in New York State?
Sure. I think it's important for everyone to remember that we're pretty much in the middle of the crisis, the pandemic. And, the world has sort of survived since March. At least the legal process has worked pretty well based on my sense of it. And those flexible rules have really, done well. I practice law in New York City, and we've been through, crises before, 9/11, then we had Sandy, and those crises have been, sort of dealt with in a good way. As far as I can tell from where I'm sitting, this will end, and I don't think we're going to go to a world of remote trials, for example, once the pandemic is over, or once there's a vaccine. As a practicing lawyer, I don't like the idea of doing oral arguments by Zoom. I can't tell how the judge is reacting. It's hard for me to even tell what the opposition is doing. So I don't really favor that. I think that the status conference that I would fly across the country, that was a 15-minute or a 20-minute status conference, that may be a thing of the past, and that's a good thing. I think the one area where I actually think the pandemic could have a long-lasting effect, and it's been discussed already by Rick, is on depositions. We've started to do remote depositions, and again, it makes the process faster and cheaper. People don't need to travel. Now, there are issues that get raised, and one of the big ones that we've come up with is if I'm defending a deposition, I like to be with my witness and be in, close to the witness, so I can sort of sense how the witness is doing. I can have breaks. It's one thing to talk to someone over the phone. There's another thing to have that human interaction. And we've had situations so far where people have, we've wanted to maybe be present and defend the deposition. And the way the rule has sort of worked out has been one of everybody is remote. Now, once there's no reason why people can't be in the same location because it's not an issue of a contagion, one issue that will come up is what if the person who's defending the deposition wants to be in a conference room with the witness, and then the taker is, in California or in Texas or some other place? That's an issue that I think could come up. Now, the rules, I've been involved in the course of my life. I was a law clerk at the Supreme Court, and then I worked in the Senate, and now I'm involved in the Rules Committee. The Supreme Court is the highest, law of the land, but that's one where, decisions and cases they're made relatively, quickly. Sometimes, weeks, sometimes days, an opinion can be changed. And that can be, the law of the land. It could happen in a law constitutional case. And there's not a process for people to really, the outside world really can't get involved other than through the formal process of briefing and oral argument. And then the justices obviously talk amongst themselves. The Senate is a more open process in that, people can lobby, and it's pretty much the wild, wild west. The rules process, as I've learned now in a little under 3 years, is a very deliberate process that takes time. It doesn't happen overnight, and I think that's a good thing. These rules are really, carefully done, and people like Rick have devoted their lives to the rules, and the rules are very flexible. And I would be loath to make significant changes to the rules in light of something that hopefully will end. We are not going to be living in a COVID world for the next 5 years. All we'll be doing is looking back at this period and sort of saying, well, what were some of the good things that happened that maybe we want to continue? And like I said before, I think, the conference that you fly across the country, that will probably become a thing of the past. I also think that, there'll be, remote depositions, and I think people will work more from home. Do I think there needs to be wholesale changes to the rules? Probably not. Now, I think it's also important when you think about rule changes to consider, local rules versus, a national rule. And even in New York, where which was the center of the pandemic, say in April, and the state was really shut down. As the state opened up, first the opening happened upstate and in the suburbs and now in the city. And so that makes sense because, given the nature of the pandemic, you obviously deal with things in different ways. Now, at the state level in New York, our chief judge, Janet DiFiore, and I think, there's a saying, never let a crisis, try to take advantage of the crisis to do something good. She has created a commission to reimagine the future of New York State courts. And she's appointed a number of lawyers and a lot of judges, including judges on the New York Court of Appeals, which is our highest court. And the goal of that commission is to, quote, research, analyze, and make innovative proposals for the justice system of the future, and to consider regulatory and structural innovations, enhanced use of technology and online platforms, and to come up with ways to more effectively and efficiently adjudicate cases. And this is an important issue: improve the accessibility, affordability, and quality of civil legal services for all New Yorkers. I think what could come out of all of this is an enhanced appreciation of technology. Now, we were heading in that direction anyway. And one of the things in New York we're doing, and I'm co-chairing a subcommittee on trial practice, and we're looking at changes that might be made in the rules, for example, rules of evidence, to deal with evidence that's being generated through enhanced use of technology, how you run a trial with more technology, greater use of technology. I think the rules actually, in both New York and federally, really are sufficiently flexible to deal with a lot of these issues, such that I don't think there's a need for any kind of wholesale change in the rule. I do think, for example, I don't think we'll be coming to the point where maybe we will in 200 years, we're all not gone, where we have, computers decide small claims court disputes. I mean, that's theoretically possible. Maybe there will be, I remember when I was a young lawyer and we would have to rush to get the brief done at 5 o'clock and literally get it filed at the courthouse physically. And now everything is done by computer. That's great. good for the environment. It's faster. The process is a more efficient one. When I try cases now, no one really bothers with all the different rules you learned in law school. And I went to Yale Law School, so they didn't teach us much law, but a little bit. About how to get evidence admitted. That's all pretty much done in advance of a trial. Things are much more, are fast. And I always tell people, when I do a trial now, it's largely the person who's the technician in the courtroom is probably one of the most important people in the whole thing, because if that person doesn't, if something goes wrong, the whole trial sort of stops. But everything is really done, with computers, remotely, a lot less paper, and probably will move further and further, in that direction. So, my bottom line is, I think we'll all learn from this experience. Just as, my law firm, we learned from Sandy, we learned from 9/11. And one of the reasons we were able to function, it's incredible, but, our firm is just as active, if not more so than before the pandemic, because we have fairly sophisticated technology that we put in place after 9/11, after the Sandy storm. And I think what will come out of this will be, it will end. I don't think there's a need for wholesale, and it's hard to even think of many changes you'd make in the rules. And Rick is right. The criminal rules are the ones that people have been most focused on, because those are the rules that are harder to change. But I think that, it could be things like, like I said, the court appearance that's for a very short period of time, and things like depositions, which will be, that kind of thing makes sense for a remote process. But I'm not sure you really need to change the rules to deal with it. And to the extent we need to change the rules over the next, until we get a vaccine, which, that's probably, depending on who you talk to, 3 to 6 months away. The rules process itself is one that takes 2 years. So Rick can write a great rule, but by the time it gets to the Civil Rules Advisory Committee, and then gets to the Standing Rules Committee, which only meets twice a year, and then gets to the Supreme Court, I don't think that's probably the best way to get a rule put in place. And my, impression from on the ground has been, local courts, whether it's the Southern District or, in New York or in San Francisco, judges are able to develop bespoke rules to deal with the crisis. And I don't think, there's a need for a national rule, particularly since the crisis is one that, impacts different jurisdictions differently at different moments in time. So bottom line, I think we'll come out of this with some, changes to our way of litigation that will be a positive, but I don't think we really need to make any wholesale changes.
So, Bob, I agree with you that technology has enhanced the way we litigate in so many ways, particularly since I started. But I think we always need to keep in mind.
I remember carrying the boxes to court when we were trying a case, and I did that once in Boston in the snow in January, and it was pretty rough.
Well, at least you didn't have to wear high heels.
Much harder.
Yeah, and a skirt. But I do think that whenever we're thinking about these issues, it's important to remember that there's complex litigation and firms that are capable of dealing with it, but the vast majority of the litigation that's in both federal court and state court are small cases, a lot of in pro per cases, and we continue to deal with the digital divide. For some litigants, people with disabilities, the technology actually is helpful, but for others, it can create a distance between them and the court system, which is theirs. And so, what are your thoughts about how we continue to think about ensuring that whatever changes we make are ones that work for everybody in the system, and then also avoiding what I think is easy for some of us to deal with, but much harder for others to deal with, which is a lot of variation between courts?
Well, number one, I think you're absolutely right. I mean, technology is expensive. Big law firms and government agencies can afford cameras on people's computers and mainframe computers and all the different things we need. In New York State, one of the things that we're focused on is we have a commission for equal access for justice that I've been on for a number of years, and we're very concerned about what's called the justice gap. And Helene Barnett, who I used to run the Legal Services Corporation, is the chair of this commission. And my practice, as I recognize, is a pretty rarefied practice involving sometimes multi-billion-dollar claims where money is no object, and it's really about just getting the best possible resolution. But if you look in, say, New York State Court, 95% of the cases are, or maybe even more, small claims court cases. People who have disputes over credit, landlord-tenant disputes, family disputes, and they're important cases to the people who are litigating them. It's possible, and I think one of the things that I think Chief Judge DiFiore wants her commission to do, and as I read the charter, is to see how we can use technology to make the courts work better for people and make it work better for the smaller dollar cases, the cases involving, say, a landlord-tenant dispute, the case involving a family law issue, and trying to, for example, develop forms where people can go on a computer, which people I think are increasingly, not just younger people, but everybody is much more facile with technology. And so, when you think about the federal rules of civil procedure, those are rules that are really set up for, big cases, to be blunt. You have jurisdictional limitations and the like. No one is going into federal court litigating over a landlord-tenant dispute or a domestic dispute or, a small dollar case. And, we often forget, people probably are on the Zoom, that the vast bulk of the lawsuits in America are these small dollar cases. And I think we're just scratching the surface in terms of how technology can be used to more efficiently and fairly and at a lower cost resolve those cases. And one of the problems we've had in New York has been that the judges are almost overwhelmed because you have for example, domestic dispute cases. We have fairly good legal services there, but there's obviously not a right to a lawyer in a civil case. And so you have a lot of unrepresented people who are in the courthouse, in the court system, and the court system and the rules are really complicated. So I think one of the things that could be done is greater rule simplification in certain types of cases and greater use of technology, including standard forms, checklists, more alternative dispute resolution type devices that could be done on a computer. And just the sheer process of someone having to go down to court, getting out of work or not being able to take care of your kids. If you're someone who's not who's got financial constraints, the ability to for example, if you had a dispute against your landlord, maybe you could envision a system whereby someone, you'd have the judge, maybe you'd have a lot of it dealt with by computers and you sort of narrow the issues to the real issue. And then you could have the hearing by computer and no one would have to go to court. You wouldn't need a lawyer. And, maybe you could even have people who are full-time literally sitting in court, or the lawyers maybe paid for by the government to assist tenants in those cases. I suspect the landlords might well pay for it. I mean, one of the things we've learned in the New York Commission has been the business community actually wants unrepresented people in civil disputes to have lawyers because it becomes almost more expensive to deal with someone who's unrepresented. So I think we can use technology in that regard.
So
we also apparently have a huge backlog now of civil cases of this type that have built up over the last 6 to 7 months.
So we had a comment from the audience, which I think is also important in this conversation, which is that I think there are a lot of really good ideas, but one of the realities which very much came home to me listening to Judge Kuehl this morning was how limited the state budgets are. And so the innovations that I think really could make a difference for so many people have to deal with the reality of their budgets right now. She was saying this morning that they literally didn't have the money to pay for lunch for the jurors, so they didn't have to all go out, down the elevator in the middle of the trial. So that in a sense we are pairing the set of safety and public health concerns with the reality of a recession, which has really tightened state court budgets dramatically.
New York State, where there's a huge cut that's coming to the state court budget, including there's a program in New York whereby judges can serve from 70 to I think 76, and they're going to be cutting out all those judges, and that obviously will create even more problems. I mean, one could argue that the amount of money we spend on the state courts is a lot, but you have, there's a tremendous amount of litigation. And I do think that there is, as I said before, a bias in conferences like this and in rulemaking processes. People focus more on my kinds of cases, but the big, multi-billion-dollar cases are not the raison d'etre of most courts. So I think, what smart people like the people on this Zoom call could do is think about how we can use technology to make the system more efficient. And, maybe again, you can do things, maybe in small dollar cases, you can do trials remotely, and maybe it's a better way to do it. It depends, one size does not fit all.
Yeah. Thank you, Bob. Tara, can I turn it over to you to give us your perspective on what's going on in the courts?
Sure. Good afternoon from Minneapolis, or actually good afternoon from my home just outside of Minneapolis. Like all of us, we're working from home these days. As you probably picked up from my bio, I primarily represent plaintiffs in personal injury and products liability actions with a focus on mass torts and multi-district litigation. I think I'm here to give you some perspective from the plaintiff side as to how the rules are impacting the management of civil cases during this time of pandemic. And I'm not on any rules committee, but to give my thoughts about what changes might be beneficial to consider if, God forbid, we're ever in this situation again. But I thought before I got into the rules, it might be helpful to provide some background on what I've been seeing happening in the multi-district litigation front over the past 6 to 7 months since COVID hit. As people know, MDLs are some of the most sprawling and complex cases on the federal docket, and they're generally handled by some of the most sophisticated and experienced judges we have. MDLs also have a plethora of counsel. There's tons of lawyers on each side. And to your point, Jocelyn, sometimes on the plaintiff side, the law firms can be smaller in size and not have all the technological advantages that maybe my firm has. They're very contentious cases, and they're hard fought. They really need the rules of civil procedure and careful case management to keep them from going off the rails. Interestingly, since COVID ramped up in the spring of 2020, I have not observed really widespread extension of scheduling orders or court deadlines, except there was a case, a big MDL, where a bellwether trial was scheduled in May. That was the Zofran MDL in the District of Massachusetts, and Judge Saylor had to reschedule that trial. Actually, he's postponed it and hasn't found a date. And interestingly, one of the problems that the court is facing is in order to ensure safety, there's no room in that courthouse that's big enough to conduct that trial. So they're looking at alternative venues outside the courthouse, which implicates potential rules issues. But really, from what I've seen, the courts have been pretty quick to shift to video conferences for hearings. The parties have been able to work out depositions that sometimes they're in person, but it seems like more often than not, they're being held remotely by video. While remote hearings are the norm for now, There are instances where courts seem to be requiring in-person hearings, even witnesses in person. I was involved in an opioid case, which is brought by the New York Attorney General in Suffolk County, and the justice there ordered that the Fry hearings, which are the hearings concerning the admissibility of expert testimony, be conducted in person. And those hearings happened in August and September. He set aside 9 days. He only had one witness per day. He placed limits on the number of attorneys who could be present in person. But he did allow counsel an opportunity to participate by video. He did the same thing for the public and the press. He allowed physical exhibits to be exchanged. So there are hearings with witnesses that are happening, and that's the type of hearing where you want to see in person. I agree with Bob. And then if you look at the opioid MDL before Judge Polster in Ohio, which people have characterized as probably the most complicated piece of civil litigation ever, he had a bellwether trial set for November of this year, and he is going to proceed with it. He has said he will seat a jury in November in Cleveland, Ohio. We haven't seen the detailed plans for what that's going to look like. And I think, Thimby, I have a PowerPoint. If you could go put that up and go to slide 2. I have a feeling, I'll get it up here. And then just turn to the next slide. I have a feeling that it's probably going to look a lot like this. This is what the courthouse in Minnesota looks like. They're going to start trials shortly in Minnesota, and they put up plexiglass. And then, interestingly, in one of the cases that's been remanded in the opioid litigation to West Virginia, both sides have agreed that the case, which focuses on a nuisance count, is going to be a bench trial. So obviating the need for all the procedures we're going to have to do to deal with juries and juror safety. If we can move to slide 3, just want to kind of build on what others have said before me. To the extent there are going to be changes in the federal rules, and it sounds like that's still up in the air, and there are differing views on that, I think there are a number of principles that should guide the advisory committees as they consider changes to the rules for times of emergency. And I totally agree that there's a tremendous amount of flexibility already in the rules. And we've seen that at work and how the courts have been operating and continuing to prosecute cases over the past 7 months. So I really do agree with Rick and Bob that there should be caution exercised with respect to any changes, because the flexibility in the rules really allow the courts to conform the procedures in their case and the management of their cases to what's really going on the ground in the communities where these courts are located. Because as we know, there's vast differences across the country, and there's also vast differences in orders and executive orders that have been entered by governors that courts have to contend with. It's been an ongoing issue that there are no national standards in this crisis. But if there are going to be clarifications, I do think there are some that would be helpful. I think one would be clarifying or making changes that eliminate requirements of in-person contact where it's unnecessary or unsafe in times of an emergency. I think we all are seeing the benefits of technology. So changes that encourage the use of technology, changes that would decrease the need for travel. And I think also, as the rules are being looked at, how can we provide for comfortable and safe jury service? But at the same time, too, and I wanted to echo, I was thinking the same thing that Rick had said earlier, to the extent we are going to make changes or an emergency rule, I think we need to consider how maybe some of these changes, look at how COVID has changed the practice of law, and have some of those changes been actually made it better, and not just safer? And are some of the processes the courts implementing making litigation less costly, more efficient, and are they driving cases towards resolution? If they are, then I think we should be considering maybe making some of these changes, if they're to be made, permanent. Just to go quickly through some of the particular rules that I've been thinking about, and I think the committee has gotten suggestions about. Rule 4, this doesn't seem very controversial to me, but I mean, a simple amendment to permit service of process and a summons and complaint by electronic mail. This type of change would protect process servers and the U.S. Marshals Service. It doesn't seem like, it seems like it could be something that would streamline litigation, both in emergencies and going forward. Next slide. So I think here's the thing that I worry about the most is whether this pandemic or a future emergency is going to delay discovery or the resolution of a case. I always think of the maxim that justice delayed is justice denied. And in my types of cases, delay disproportionately can impact the plaintiff. Documents can go missing during delay, memories can fade, employees leave. In the meantime, clients in mass tort cases are typically sick, and if there's delay, they can grow sicker, and sometimes they'll pass away before the case is done. My experience to date is, I have had some cases where the defendants are saying that they can't review documents and produce documents, and depositions can occur because of COVID. The facts don't bear that out. We all know that. Documents are stored electronically. They can be reviewed remotely. Depositions can be conducted remotely. But anyway, in terms of the rules, things that might help avoid delays from pandemics, I think the rules should take into consideration situations where it's going to be a safety issue to be in person, either for testimony or inspecting documents. So I hope that the committee is considering whether the in-person requirements of rules, for example, 28, 30, 34, 35, and 45 have to be updated. I think another thing that would be really helpful if there are going to be changes is that the committee comments really encourage, in situations like this, that counsel engage in meet and confers and conferences. I think similar language about the value of meeting and conferring is making it into the advisory comments for 30B6. I really think a civil dialogue is very important, especially when some of our clients, their offices are closed, courts are closed. So any encouragement of meeting and conferring to stay on deadline, I think, is helpful. I'm really worried about any change some blanket change to extend deadlines that are set forth, or timelines that are set forth in the civil rules. I don't think that that's really necessary. Most of the work that lawyers need to do to meet deadlines can be done remotely. I think Rule 16 is really a friend in this whole situation. It's a wonderful tool for the courts to manage discovery during emergencies. I think it's the way courts can make sure Rule 1 is satisfied. And one possibility would be whether or not a Rule 16 conference should occur if there's a declaration of an emergency to discuss court scheduling orders, or whether we need to have more Rule 16 conferences. I mean, that's something that parties can make a request as well. I think that I have seen that video conferences with the courts, they're not the best, they're not ideal, but they work. I think they're really important for discovery conferences and discovery disputes. One thing that I think we've all seen is that the pandemic really kind of taxes all aspects of our lives. It seems like everything is more difficult. So I think any attempt to encourage courts to permit more informal processes for dealing with discovery disputes would be great rather than formal motion practice. I have a case in Minnesota State Court involving it's a big products liability case, and the judge has an order where she just allows us to schedule a telephone conference, submit letters, and then she mediates the dispute, and we can get it all resolved very quickly. And I can tell you that process in COVID has just made everyone's lives, the court's lives, the parties' lives, tremendously easier. The next slide, remote depositions. I think I agree with Bob. They're probably not going away. I think attorneys have been doing them for years, but there's a lot of us who are just learning how to do them effectively. I think there has been talk about whether or not Rule 30b-4 needs to be changed to provide a default that the depositions can be held remotely rather than getting into motion practice. There's some issues around under 30b-5 and 28 about court reporters because a court reporter is not physically located where the witness is. I think that is a rule that actually does need to be looked at because under Rule 32, it provides that you can object to an oath if it's not properly administered, and if the witness or if the court reporter is not in the room with the witness, you may face a Rule 32 objection. So I think that one does take some serious consideration. Witness coaching, I do like to be in the room with my witness to help defend them, and vice versa when I'm taking the deposition. But one of the concerns I think all of us have when we're taking depositions is this issue of witness coaching. But this isn't so much asking for a rule change, but I just think there are provisions in the rules that could help on this front. Rule 30, I would remind people to keep in mind, which requires that depositions proceed as they would at trial. And at trial, of course, a lawyer can't sit beside his or her witness. And there is case law out there that if a witness is texted during a deposition, that violates Rule 30, and that text isn't privileged. So I think that just shows the flexibility of the rules. So I think another potential solution for the witness coaching that doesn't require any rules changes is I've seen recently in the Western District of Texas, a court dealt with this issue by requiring the court reporter to disable chat features on video conferences. Also, the judge entered an order where a witness has to sign a declaration at the end of the deposition where they say under oath that they haven't been coached. So there are ways to deal with this problem that does exist with remote depositions, and I don't think would require rule changes, but just more practice, instruction, and guidance from the bench and the bar.
So Tara, I have a question. I agree with you. I don't think that we want to write rules just to deal with the people who don't want to follow them. But I wonder whether technology also might provide a solution, because if there was a camera that was essentially trained on a witness and his or her lawyer, you could just potentially have a record to see whether or not they're passing notes, chatting, doing the foot under the table, all that.
Yeah, I think it's when it's remote depositions, it's probably a little trickier than just a camera, because you can have, like right now, I have my phone under under the desk and you can't see it, and I could be texting a witness. So I thought that the solution of the declaration that came out of this Western District Texas case from April was an interesting thought. Another thing too is a lawyer could handle it by, at the close of the deposition, asking a series of questions to the witness as to whether or not they received any information during the course of their deposition from their attorney or someone, other person who was assisting them in their testimony. And perhaps figuring it out that way or getting your record. Of course, you have to believe that they take the oath seriously and they're not lying. But it is certainly an issue that I think all of us worry about, particularly in some of the high stakes cases we're involved in. So then just the last topic really is about getting back to work, getting back to trials, and how do we protect juries. We've seen that courts are starting to restart trials, and there are a lot of guidance documents that are floating around. The judicial working groups have put documents together. ABOTA has put documents together. I really think that all lawyers, plaintiffs, lawyers, defense lawyers have a lot of concerns about whether a completely virtual trial can provide a fair outcome. I think they tried one in California. There were security and technical problems. It's really difficult for counsel to read body language and other important credibility markers if it's remote. Juries lose the group dynamic, all the bonding and trust that comes from deliberating as a group. Not to mention you're going to be potentially excluding jurors from a panel because they have poor internet. They're not going to be able to participate as jurors. But that said, are there rules that could be considered for tweaking to allow flexibility, more flexibility in trials? And I think, in particular, Rule 43, it allows that testimony, it says testimony should be in open court, except upon good cause and compelling circumstances. I think that rule probably is written in a way that would cover a COVID situation. Could it be clear, or more explicit, perhaps? I think Rule 45, which is about the subpoena power of a court to command a witness's attendance, I think that one is one that we should consider whether or not it should be amended to permit witnesses to appear by video if good cause is shown in appropriate circumstances. I'm not sure if that one's on the plate of the committee, but I think it's one that could be looked at. And then I think about Rule 77B, which talks about the trials are in open court and in a regular courtroom. Well, open court, if your courthouse is shut down, which many of our courthouses were shut down, it's not an open court. It's not a court that the public or the press can get into, which they have a First Amendment right to. And then, like the situation in Zofran, has to be a regular courtroom. What does that mean? Does that need some more explanation in times of emergency, or does it not? The situation in Zofran where the judge is going to have to pull that trial outside of the courthouse. And I don't know if it's going to be a hotel or where it's going to be. Is that going to be an issue? Is it that too granular? But anyway, those are just some of my thoughts about if rule changes are considered. I think some of these are potentially fair game and would help facilitate more efficient justice in this time of lockdown.
Tara, I have two questions for you, and I'd love Bob's thoughts about these too. This morning we heard from one of the state court judges about the fact that because she is not doing trials, she has a whole lot more time and is much more available to counsel to deal with discovery dispute status issues, and feels like she can be a much more active case manager because she all of a sudden has much more free time on her hands. My question is, are you observing that as well? In other words, the judges literally have more time on their hands to get you decisions more quickly, to respond to problems as they're arising. And then, Tara, you were mentioning, the need for additional collegiality. And I'm curious if your experience has been that COVID has brought out the best or the worst or some of each in your opposing counsel.
Right. My experience has been, I do think that judges are more accessible. Just like I can't ever get away from Zoom. I feel like I have more meetings now than I've ever had. And for some reason, because we're not traveling and we're not in our cars, we're not commuting, we have more time. And I think that applies to courts as well. So my experience has been it is easier to get on a court's calendar. And that's why I think the embracing more informality, Zoom itself is a little more informal, and you got the dog in the background. I think that could translate into how we resolve disputes as well, and it would save our clients money as well, because if we do things more informally, we don't have travel, we could have lesser time put into briefs. It could be more in the way of letters, which I have thought that judges seem to be more receptive to now. And things get decided more quickly. In terms of civility, that just depends on the case. I'm seeing it both ways. I think at first it was maybe a little more generous. People were still in shock of what was happening, but I think as time has worn on, we're getting more entrenched in our old ways.
Bob, what about you?
I think courts have really stepped it up in terms of getting decisions. I was always worried about whether the courts would actually shut down. I've been surprised that it's kind of moved at the normal pace in terms of the issuance of decisions. There are obviously less hearings, and I really do believe that it's not in the interest of the justice system to have everything remote, for example. I mean, I've had situations recently where we're talking on just a telephone, for example, and you're talking to a judge, and you really can't read the situation very well at all. And I've sensed that judges are a little frustrated by not being able to have people, in the courtroom, particularly if it's something that is important. I haven't really seen any difference in terms of speed of decision or anything like that. Maybe even a little slower, to be blunt. In terms of civility, there's been, particularly the first 3 or 4 months of this, we really dialed back the depositions because we thought, oh, why do we want to do depositions remotely? So that part of it has slowed down. Now it's starting to pick up, and we're going to try to do things remotely. I haven't sensed, anyone. If anything, there's been less interaction with the other side. When you see people face to face, whether it's in a courtroom or in a deposition room, there's more interaction. So the people who behave civilly, you're sort of with them, and the people who are always, uncivil, you're just kind of dealing with them by email or by letter. Again, I go back to what I said before. I think that it's a mistake to focus too much on the COVID situation, but we need to focus on what things will look like when we get on the other side of the tunnel. And, I do think there'll be more remote depositions, all this, things people can do to get, a break. I will say that if someone wants to take a deposition and they're located in California and my witness is in New York, and I want to be in a conference room with my witness in New York, and maybe the court reporter is with my witness in New York, I should have every right to be with that person. And if the other side is concerned about gamesmanship, I think Tara's suggestion of questions is perfectly fair game.
So, Andrew, you obviously spend a lot of time thinking about the civil rules. So could you share with us your thinking about all of this?
Sure, thank you. I think it's appropriate that our panel be the one that's in the middle of the day, since I think inevitably we're covering matters to some degree that were discussed this morning. And we're also talking about the extent to which changes that are brought into effect, whether formally in the rules or even culturally as a matter of the way that we do litigation, will survive into the post-pandemic world. And perhaps one of the perils of being the last person to speak on this panel is that I'll agree with a lot of what has been said already, but I'll do my best not to be too repetitive. I'm in a slightly different position from my fellow panelists, because unlike Rick, I'm not involved in the rulemaking process. And unlike Tara and Bob, I'm not a full-time litigator. But what I am in the middle of is teaching first year civil procedure to 121 Ls on Zoom. which I think does give me some insight into the challenges of the virtual world that we find ourselves in. But one of the things I've been trying to do as we go through the first year procedure course and some of the classics of first year procedure is think about how COVID has forced us to change the way we think about some of those core concepts. As I told my fellow panelists when we signed on before we got started today, I'm currently teaching the Erie Doctrine, and perhaps thankfully COVID has not caused us to have to rethink that, but who knows, as state procedural changes may vary from what ultimately happens in the federal system. So I think in my short remarks, I'm going to make 2 points, and some of it will be in reaction to what other folks on the panel have said. But the first one is that I think COVID and a lot of the workarounds that we are coming up with in procedure and what's been proposed along over the course of the last hour or so does force us not just to rethink the minutia of the rules, but some of our core concepts of the adversary system and the ideal of a day in court. And if those changes become permanent, there will be significant ripple effects on the norms of our litigation system. The second thing I want to say, I think drawing on some of Tara's comments, is to draw an analogy to MDL and how multi-district litigation, which was also a response to a perceived crisis, albeit a crisis very different and far less severe and tragic than the one that we're currently enduring, is one that I think does nevertheless have some parallels to the way that we're handling things now. So first, with respect to COVID and its effect on procedure generally and potentially going forward, I agree with the view that I think in Professor Marcus's words, that the civil rules have borne up remarkably well during the pandemic. I think the credit for this goes perhaps to the Rules Committee and their predecessors, perhaps all the way back to the 1930s, in the sense that the rules were built to have a kind of open texture to them and a kind of flexibility to them that would respond to various circumstances. Indeed, the trans-substantive nature of the rules to some degree gives them the kind of DNA that makes them sufficient to cope with unusual circumstances, and also gives discretion and power to judges and lawyers. Indeed, the new hortatory language or I think of it as new, hortatory language in Rule 1, that judges and lawyers and parties are supposed to work together to achieve just, speedy, and inexpensive litigation, I think is something that's built into the rules. But I do think that what the crisis is doing is making us more comfortable with doing things ever more virtually. We've heard people talk about status conferences, motion hearings. The Judicial Panel on Multi-District Litigation did their hearing remotely last Thursday, but also things like depositions, settlement negotiations, mediations, and perhaps even jury trial. I think one of the things that we've learned is that this flexibility does obviate the need for a knee-jerk emergency kind of Rule 87 that Rick got us started off. But that doesn't mean that without such rule changes, it's gonna change the way we think of the real-life interactions of litigation. So, within this world of virtual interactions, one of the things that I've picked up from teaching my students, and indeed I've got this group of 120 students at Berkeley who are being acculturated to life as a lawyer through virtual remote interaction. That is, they're not coming into the profession in a face-to-face world. And oddly, I think it was borne out by the law schools. Many of us thought that we would have smaller 1L classes this fall because students would prefer not to take the first year of law school virtually, perhaps in part because their other options were few, but also because they're just comfortable with virtual interaction. They've come in droves to law school this fall. And so they're entering the profession in a world that's very different from what all of us have experienced. And so when I've taught a lot of the stuff that's kind of the the bread and butter of the first year course, I've tried to think about, well, how has it changed? What is notice reasonably calculated to provide actual notice under Mullane in a world that is primarily virtual? Is there anything left to inconvenience-based rationales for limiting personal jurisdiction, for instance? What do we need to do in virtual depositions to ensure that they are able to present the ability to interact with one another, not just clients, but also opposing counsel, when we're doing it in this sort of setting? And maybe even more generally, I mean, what does it mean to a system that purports to care so much about a day in court if your day in court is on Zoom? Does that satisfy the kind of dignitary purposes of many of our procedural rules? And I think, you know, the conversation that was going on between Jocelyn and Tara and Bob and folks in the audience is really a useful one. Is that, to what degree does technology level the playing field in between parties of different resources? Will COVID create kind of an economy of scale of virtual interaction in such a way that it reduces the kinds of imbalances that parties may have in terms of resources? Or could it exacerbate those problems? And does that change depending on whether we're talking about aggregate mega litigation or the kind of litigation that we see often result actually in default at the state court level, particularly in contract actions? And perhaps separately, and maybe this is something that's a little bit separate from the rule change piece of this, but I don't know. I mean, maybe perhaps I'm talking mostly to the academics in the room, but some of us are in this business because we're introverts. But none of us are so introverted that we really want a world that's devoid of human interaction entirely, even if that human interaction arises in the context of a dispute. So I wonder what it means sort of generally for the collegiality of the bar that we're not having the extra curricular interactions in the hallways and the hotels and that sort of thing that we're not having in a world where we sign on and off of Zoom 10 times seriatim over the course of the day. So those are all things that are sort of in the background here, but I think that these kinds of rule changes that facilitate additional virtual interaction are something that are inevitable in the post-COVID world. That doesn't necessarily mean that we need to have a lot of rule changes, but there's something that I perceive will be considered very comfortable to our up-and-coming generation of lawyers, who all of whom will have experienced a lot of their legal education in this kind of format. All right, that also brings me to my second point, and that's this question about how notions of a crisis can lead to permanent changes that persist after the crisis abates and spread beyond the confines of what the original crisis actually was. And picking up on Tara's points and some of Bob's points about his particular practice, I thought I'd talk a little bit about aggregate litigation and multi-district litigation in particular. So MDL, and to a much lesser degree, although somewhat, the 1966 amendments to the class action rules were born out of a crisis. That crisis is not in myriad ways at all like the one we're currently dealing with, but it was nevertheless a crisis in the courts, and that was the massive litigation involving price fixing throughout the electrical equipment industry. And it was in response to that unprecedented litigation that Chief Justice Warren created an ad hoc committee to deal with the crisis, the Coordinating Committee on Multiple Litigation. That committee was not chosen by accident. It was composed entirely of judges who were enthusiastic about novel ideas about case management, or then somewhat novel ideas about case management, at least among the federal bench. And that litigation spawned, without any changes to the federal rules of civil procedure, many of the innovations that we now consider sort of de rigueur in aggregate litigation. Stuff like coordinated discovery, steering committees of counsel on both sides of the litigation, tracking of cases, judicial involvement in settlement negotiations, case management orders and regular status conferences and supervision, and more. The crisis also begat, as our current conversation does, a somewhat growing consensus that the electrical equipment mess would not be a one-off, That is, I think one of the things underlying the provision of the CARES Act that directs the Judicial Conference to think about these things is that perhaps these kinds of crises are not going to be are not going to be one-offs. They're not going to, we may have crises related to natural disasters. We may have crises that aren't related to future pandemics, but are nevertheless reasons why the court system's general way of doing business will be challenged. So the view in the 60s was that, like today, this may be only the tip of the iceberg. Now, the concern in the 60s very much was that we were going to get a litigation explosion. And the terminology litigation explosion was used by those at the time who really were demanding that the federal courts get with the program and develop machinery to handle the next wave of litigation that was going to inevitably come. That we were going to have an interconnected economy. We were going to have many more new causes of action created by the Congress and created by changes that were happening in the 1960s, and that law was going to facilitate those things. And so the litigation explosion as a crisis in the 60s was a call to action to figure out ways to efficiently handle litigation, and not, as it's often used today, as a call to make that litigation go away. In the names of not overloading the courts. But anyway, what we got out of this crisis was not only the MDL statute, which came in 1968, but also a lot of other reforms that are less formal. We get the Manual for Complex and Multi-District Litigation, whose first edition comes out at the end of the 1960s and was written by all of the same folks who were involved in electrical equipment. And the Manual for Complex Litigation may be more of a useful model of thinking about the way COVID is going to affect future litigation than changes in the civil rules, because it's the manual itself and practices by judges born out of their experiences as litigation proceeds that have changed the way that litigation is practiced. And indeed, the Manual for Complex Litigation, in the sense that it changed the way that we think about big cases, has very much filtered down to the way we do small cases. That is to say, the approach to case management engendered by thinking about the so-called big case in the 40s that became complex litigation in the 60s is really the way that we think about regular old litigation in 2020. So when Bob talks about bespoke rules and local rules, and Tara invokes Rule 16, those are all ways in which we might start to see a filtering from COVID into the way that we think about litigation more generally. So COVID, of course, is a crisis on a wholly different order than antitrust litigation, but some of the dynamics are the same, and in part in relation to the way that courts are innovating and the way the federal rules and the multi-district litigation statute facilitate innovation. We're seeing sort of replayed now alongside what I think of as a broader cultural rethinking of the way that we're practicing law and practicing litigation that we're seeing starting for our very newest lawyers already in law school. And so I think if there's one thing that this discussion, at least on this panel, has borne out, is that while we may not see very much in the nature of rethinking the federal rules, not only is that consistent with our federal rules system on the civil side more generally, it's also consistent with the way that litigation has simply evolved over the course of the last 82 years since the federal rules came into being in the first place. So I will stop there and thank you for allowing me to be a part of this.
So Andrew, thank you so much. I am not an MDL lawyer, but I have heard about some of the things that to me have always seemed just remarkable, and I'm wondering whether we will see the end of these things. So what I understand is in circumstances where they're trying to decide whether or where a case should go, there can be literally hundreds of lawyers who fly to one courtroom, each of whom is given a minute or less to make their pitch about where a case should go. And then once a case is assigned, you have that same process when people are competing to be on a steering committee, where there are literally hundreds of lawyers flying in to each speak for less than a minute or a minute. Tara,
it happened in Volkswagen, where we had literally, I think 200 plaintiffs' lawyers made presentations to Judge Breyer. And I mean, it was literally everyone from, David Boies to John Edwards, all looking to get a piece of the case. Quite amazing.
Yes. So will that continue?
I don't know. My guess, I think along the lines of many here, is that probably not, perhaps because it's just so expensive to do that, right? And particularly, you think about the judicial panel on multi-district litigation, oral argument is typically limited to 1 minute. And so I called into the JPML hearing last Thursday morning, and it was remarkable, certainly, how that went without being in the room. And I was also there thanks to my local proximity to get to go to the Volkswagen beauty contest, where there seemed to be an endless line of lawyers, coming in to try to take their couple of minutes to convince Judge Breyer that they should be, at the apex of these cases. So, I think, maybe these things will go away, and maybe it's a good thing. Maybe they'll go away simply as a matter of the fact that it's just not worth the candle in a world where we could do it on Zoom. But I also think there are costs to that. I've heard anecdotally that these, meetings of the JPML, for instance, are opportunities for the bar to gather and do a lot of extracurricular work when they're in person with one another, that stretches far beyond and has greater utility than the 1 minute oral argument that you get before the panel, which may or may not turn out to be, dispositive of whether they decide to create an MDL or to whom they choose to transfer the cases. So there is a cost there to losing the extracurricular interactions, negotiations, even the collegiality of getting together and being together in one room. I mean, maybe for law faculties, that's an unmitigated good. But for lawyers, I think it's got costs and benefits.
Okay, Tara, are you
Jocelyn?
Yes.
Can I offer a current events comparison in the Zantac case?
Yes.
Which is pending before Judge Robin Rosenberg in the Southern District of Florida, and she is also a member of the MDL subcommittee of the advisory committee. I don't know what to say about the camaraderie that Andrew mentions, but she had 63 applicants for leadership positions in that litigation, and after considerable effort, but interpersonal actions via Zoom, I believe, with all of them, seems to have been quite satisfied with the review of those candidates, and coupled it with something we're looking at now called a census, getting an initial feel for what the cases look like, including those on what's called a registry, that was all handled online. So maybe things are different, but it's at least possible that things are working better.
So Tara, are you going to miss the schmoozathon or?
Well, the beauty contest at the beginning of the case I agree, it's extremely expensive for everybody, and oftentimes can be just kind of a circus sideshow waste of time. I've even seen it get to the point, not only do you have bring everybody in and they do their little pitch. I know of one MDL judge who even hired a special master to help her go through the candidates on top of it, which just seems like yet another unnecessary layer, something that could be simply done on papers. So, I think if that goes away, that's not a bad thing. But I do think that, in terms of hearings after leadership is picked, it is because leadership typically is all around the country. It's a good chance to be collegial and to brainstorm and be creative about how to move the case. And sometimes there are cocktail parties with defense counsel and even the judges there. So you kind of miss out on building those trust relationships that come from that.
So just to sort of bring it back, taking us out of the rarefied era of MDLs, we had a question from the audience about how self-represented litigants can weigh in the design and development of the emergency rules to the extent there are any. Rick, did you want to address that?
In the first place, not exactly on that point. If you go to the www.uscourts.gov website and look for rules comments or suggestions, you will see there's, I would say by now, 10 urging that in light of the emergency, the permission criteria for pro se litigants to use CMECF online filing be changed. I think more generally that my experience, I think Tara mentioned the Rule 30b-6 change that pretty certainly is going into effect 2 months from now.
Pretty minor change.
What?
A pretty minor change when you think about it.
I agree, and that leads
directly to what was originally proposed, proving that the process is slow and careful.
With the discovery changes in 2000, with the class action changes in 2003, with the expert discovery changes in 2010, we would get about 300 comments. You know how many comments we got on, well, maybe Bob, you remember how many comments we got on the Rule 30b-6 change?
A lot.
1,782. Yes, we do hear from you.
For a very minor change.
Yes.
I mean, I think the question that was just asked is an excellent one. And I do think there, again, is a bias in favor of big litigation, expensive litigation, MDL litigation, which makes sense. The federal rules are certainly not designed to deal with self-represented people. I mean, you need to be pretty skillful to even understand the federal rules and to operate under them. There certainly are groups, maybe, it's probably the Legal Aid Society and groups like that probably need to lobby. And most of the cases that we're talking about are not in federal court, and make sure that, the technology is used to make the legal system more efficient and friendly for the average person, because it's not right now.
Okay, we've come to the end of our time. Does anyone want to make any last comments, any last questions? Rick, is that your hand up?
No.
Okay. Okay, then we will conclude. Thank you so much to the panel.
Thank you.
Yeah.